Further hearing in the appeal of Attorney General of Trinidad and Tobago against Akili charges.
Yes. Much obliged, ma'am. Lord, we started yesterday by looking at the relevant statutory provisions, and we made some headway in the time that we had. I'd like to take the board directly to the judgment of the Court of Appeal, because the respondent respectfully submits that that judgment is correct, and we commend it to the board. And we'll find that judgment at page 749. And it reviews in chronological order the relevant pieces of legislation, starting with the 1917 ordinance. And in the interest of time, I will use the sections as they are set out in the judgment itself. And we will see that paragraph 42, in respect of the 1917 ordinance, the Honourable Chief Justice says that it placed a clear restriction on the jurisdiction of magistrates to grant bail in cases of murder. However, in relation to judges, no such restriction is stated, nor is the relevant section, Section 31, made subject expressly or impliedly to Section 25. It says, in fact, the section referring to Section 31, in fact, the section is permissive and drafted in the widest possible terms. In that regard, the ordinance merely preserved the distinction that existed at common law between judges and magistrates as adverted to in Spilsbury. At paragraph 43, they set out the 1925 ordinance, which they note for the first time introduced the concept of bailable and non-bailable offence. The first point is that section 5.1 says subject to the provisions of this ordinance, and then at paragraph 45 the court said it is not difficult to discern the legislative policy and intent behind those provisions. In the absence of any statutory early trial guarantees, it is an obvious attempt to balance the seriousness of certain offences and the likely sentence, if convicted, against the obvious injustice of inordinately long pre-trial detention in the face of the presumption of innocence. One can discern an obvious resonance with the local context. In the circumstances, therefore, in the absence of any definition of the term, the only way to make sense of the expression non-bailable in section 5 is to construe it as meaning non-bailable at the instance of a magistrate. Otherwise, the section would make no sense, because it would purport to give a power to grant bail for an offence which it describes as non-bailable in nature. Section 5, being in any event subject to Section 82, cannot reasonably be interpreted as restricting the broad jurisdiction of judges to grant bail under the later section, even in cases of murder. And then we go to Section 1961, the Criminal Law Amendment Ordinance, which repealed Section 5, thereby removing that reference to bailable and non-bailable offences. Now I pause here because insofar as this ordinance was repealed, it couldn't possibly form part of the saved law because it was superseded by what came next. So that distinction, and insofar as it might have been a troubling one in the context of the development of the legislation, we say insofar as it was repealed, that's the end of that. And we then turn to section 27, and at paragraph 48, the Court of Appeal says, nowhere in section 4 of the 1961 ordinance is the jurisdiction of judges to admit to bail persons charged with murder addressed. Section 4 is directed at magistrates and clearly deprives them of jurisdiction to grant bail for murder, it being an offence for which the penalty of death was fixed by law. If it was intended to abrogate or derogate from the jurisdiction of judges, the drafters could have done so by the simple expedient of including the following: no person shall be admitted to bail who is charged with treason, murder, etc., or words to similar effect. We only see words to that effect for the first time in Section 5 of the Bail Act. Section 31 of the 1917 ordinance was not repealed in 61. Therefore, between 1961 and 1976, that would have been the only operative provision that specifically addressed the jurisdiction of judges to grant bail for murder. There were no other amendments before 1976. Now, my lords, we say that the reasoning of the Court of Appeal is correct and cannot be faulted by the submissions advanced by the appellant. And I would leave this matter here and simply to note that at paragraphs 41 to 54 of our written submissions, we have dealt with this matter and supplemented the oral submissions that I've just made. The question was asked yesterday as to whether there were any instances where bail was granted post-committal, because that would obviously be significant in the context of this, in light of the concession. And may I take my lords to some examples that we have in fact found to make with that point. But before doing so, can I firstly direct your attention to the Blackstone's commentaries, which gives the 1976 edition. It's the 9th edition, and it's to be found in the bundle yesterday that was given up to my lords. I think it's page 122.
Which is this your second supplemental bundle?
Not the black binder, it's the first supplemental bundle from yesterday, sorry.
I don't think that has... Do we have it in electronic form as well as hard copy form?
We did in fact send it in electronic form as well, my lord, yes.
Right.
But I have in file form your supplemental note, which had the very useful table of contents of the 1917 ordinance and various other documents.
Yes.
We have the second supplemental bundle. But I'm not sure I found this.
Page 74 of that bundle,
Yes, I got it. Yeah. 74 of the first bundle.
Yes.
Ah, yes, that might be it. It's headed wrong, it's page 299.
Oh, I'm terribly sorry, my lord.
Is that it?
The copy I have. Yes. There should be 73 at the bottom right-hand corner.
73. So it's 298, headed public. Book
Yes,
4, Blackstone Book 4. Yes. Thank you.
Much obliged, my lord. So, my lord, if I go to 299, at paragraph 15.
Yes.
Now, you'll forgive me, forgive my reading of the Old English, my lord, but it says, it's 1883, 1783, advised by Mr. Carter, my lord. It says, such persons being charged with larceny or any other felony as specified before. Lastly, it is agreed that the court of the King's Bench or any judge thereof in the time of occasion may bail for any crime whatsoever, be it treason, murder, or any other offense, according to the circumstance of the case. And herein the wisdom of the Lord is very manifest. To allow bail to be taken commonly for such enormous crimes would greatly tend to elude the public justice. And yet there are cases, though they rarely happen, in which it would be hard and unjust to confine a man to prison, though accused even of the greatest offense. The law has therefore provided one court and only one which has a discretionary power of bailing in any case, except only even to this high jurisdiction, of course, and all inferior ones, such persons are committed by the House of Parliament, etc., which is not really relevant. But the point is, this is the Blackstones. This is the Blackstones. This gives us an accurate summary of what the position was at Congress. And then, if we go to the Archbold, at electronic bundle 1395.
It's interesting that in the next paragraph on page 300, to which you referred, the author goes on to refer to an offence being not bailable. So that may be consistent with your view that non-bailability is referring to the limitation on the power of someone other than a High Court judge.
Indeed, my Lord, yes. It supports a distinction between the magistrates and the justices and the power given to High Court judges. I'm obliged, my Lord.
I'm sorry, I didn't get the date. Could you please give me the date of this publication?
My Lord, I have to rely on my limit from Mr. Carter for
1783. Thank you.
It's volume 4 of Blackstone's Commentaries on the Laws of England.
Yes.
The 9th edition.
Thank you.
I'm obliged.
And just to be absolutely pedantic about this, that 9th edition is 1976, did you say?
No, 1870.
No, sorry. The 9th edition is presumably not 1783.
Yes, it is.
It is, okay.
So this is the original Blackstone.
Right.
That made the commentaries.
Right. Okay.
In the 18th century. And Oxford University Press have subsequently, and more recently,
Indeed.
taken the name of Blackstone through its own textbook.
Oh no, I realise that, but there have been re-editions of Blackstone's commentaries more recently published by Oxford University Press.
This is taken from the original.
Okay. Thank you very much.
But I actually have it, which is the original book.
But it is the ninth edition.
I couldn't trouble you for the covering page. Not now, but at some stage, if it could be sent in electronically.
Of course I can, yes.
Yeah, thank you very much indeed. Thank you.
The good news is that is not Mr. Carter's personal student copy of the Blackstones. I don't think I need to spend too much time on this, but the Archbolds is consistent with that position that you can get book B in both the two editions that we put before you. You'll find the 1962 Archbold at 1393. And if I take you to page 1395, it says at paragraph 202, page 1395, bail in treason or felony is discretionary in the High Court or courts having jurisdiction to try the offence.
Sorry, I'm on the wrong page here.
It's 1395.
Of the principal volume?
No, this is in the electronic bundle, madam.
Yes, but the principal volume in the electronic bundle.
Yeah, yes.
What, 91395 is the Bail Act.
Yeah.
I'm sorry, my lord. Yeah, 3313, beg your pardon. Where's the front? The one is 62 1963. 3313, beg your pardon, madam. 3313.
Thank you. And
Paragraph 202.
yes, at 3315. Yes, thank you.
Yes. When granted, and bail in treason or felony is discretionary in the High Court or the courts having jurisdiction to try the offence. That position was maintained until 76. And I now come to the cases to show that bail could have been granted post-committal at common law. The first case I'd like to turn to is at electronic bundle 1987. And this is the case of Barthélemy, and at 1987 at the top we'll see Huddleston moved for a writ of habeas corpus to bring up the bodies of Emmanuel and Philippe, and for a certiorari to bring up the depositions on which they were committed, for the purpose of moving that they might be admitted to bail. So it appears as though they were already committed. And he stated that the prisoners stood committed on the coroner's inquest and also by the warrant of a justice to take their trial at the Surrey Assizes for the willful murder of Frederick. At the bottom of the page, 3 lines up, this is Lord Campbell. We have carefully looked over the depositions in this case, and we are of the opinion that we should not be justified in interfering. At the top of the next page, 1988. We think there is evidence that the prisoners were parties to the murder. We give no opinion as to whether or not the evidence is conclusive, but we think that it is sufficient to authorize sending them to trial. It is unnecessary to consider what course we should pursue if the evidence were insufficient, for we are of the opinion that it is sufficient in this case. And we could not bail these prisoners without making a distinction between murder committed in a duel and any other type of murder. The short point here is, they didn't say we have no jurisdiction to entertain the application. They entertained it and it was dismissed on the merits because the evidence showed the evidence was pretty strong.
Can we infer that from this short passage?
I say yes, my Lord, because if the courts don't have jurisdiction, one would have thought that would be the first thing in the reasoning, to say, well, this is an abuse of the court's process because it's well known that the court has no jurisdiction to grant bail post-committal, full stop. But can I come to the others, my Lord? Maybe that they might have something a little more persuasive, my Lord. So I'll go next to the Barney's case, which is 1981, page 1981. And in Barney's case, the head note says a woman bailed that was indicted for petite treason. So this seems to be a little more on point. She was indicted for petite treason, and she was able to get bail. So we're told at the head note that she was indicted for petite treason in that she murdered her husband. And the grand jury, having found the bill, she was brought to the bar and moved by her counsel to be bailed, and that there being some affidavits read of fact by which it appeared to the court that the prosecution was malicious, and that there having been no proceedings for some time, either upon the indictment or the coroner's inquest, the court thought it fit to bail her. So this is an example, we say, in direct response to the query from the board yesterday, as to whether there were any cases that show that bail was granted post-committal. We say that this is clearly one such case. And what we'll say further is that all of these cases, the jurisdiction is exercised on a fact-sensitive basis. I take you next to the case of Regina versus Barrett and Allain, and to page, that's 1983. And at the head note at 1983, in Barnett and Allain, Regina versus Barnett and Allain, the prisoners were committed by warrant of the coroner and also by warrant of the justices of that country on a charge of willful murder, they having on their own confession acted as seconds in a duel. At page 1985, paragraph 57, Lord Campbell. The court has to see, as it had been stated in a most forcible manner by Coleridge J. in the case cited, the nature of the charge, the evidence adduced in support of that charge, and the punishment. The court has to consider the seriousness of the charge. It is murder. The nature of the evidence, there is a confession of the prisoners. The punishment awarded by law, which is death. In these circumstances, it cannot be supposed that the court will try, by way of preliminary investigation, whether this duel was a fair one or otherwise. The court can only look to the case before it. Here is a legal charge which, on the confession of the accused, must be taken to be established. My Lord, even though obviously they didn't grant it, again, there was nothing to say that they did not have jurisdiction, and they entertained it, and it was dismissed on its merits. And the relevant factors were taken into account. The other case I wish to refer the board to is at 3139. It is Spilsbury, the Queen versus Spilsbury. At 3139, consider the Fugitive Offenders Act, where a magistrate had made an order under that act committing to prison a person accused of having committed an offense under that act. And he was to await trial thereafter. And at page 3144, at the middle, the court has, independently of statute, by the common law, jurisdiction to admit to bail. Therefore, the case ought to be looked at in this way. Does the Act of Parliament either expressly or by necessary implication deprive the court of that power? The law relating to this subject is well stated in Chitties. The Court of the King's Bench and any judge thereof in vacation, not being restrained or affected by the statute in the plenitude of that power which they enjoy at common law, may in their discretion admit persons to bail in all cases whatsoever, though committed by justices of the peace or others, for crimes in which inferior jurisdictions would not venture to interfere. And the only exception to their discretionary authority is where the commitment is for a contempt or an execution. Thus, they may bail for high treason, murder, manslaughter, etc., etc. But the important point is, though committed by the justices. And my lords, I go next finally to page 3095. At page 3095, Regina versus Scaife and wife, Armstrong showed cause against a rule obtained for bailing two defendants in this case before a magistrate in the country. They were charged with having certain coining moles in their possession, and a bill of indictment had been found at the sessions. Justice Coleridge, I conceive, four lines down, I conceive that the principle on which the parties are committed to prison by magistrates previous to trial is for the purpose of ensuring their safety, ensuring the certainty of their appearing. It is on that account alone it becomes necessary to see whether the offense is serious, whether the evidence is strong, and whether the punishment is heavy. In the present case at the bottom, I think that as to the wife, there is so much reason to think from what appears on the affidavits that she will be acquitted, that it is unnecessary to continue her imprisonment.
Can you just give me the page reference again? Sorry.
I beg your pardon, my lord. This is 3096. So the wife was in fact admitted to bail. Can I just go back to the Bartholomew case at page 1986? 1986, to just read a couple lines that I omitted. At the top of page 1986, this is Lord Campbell, and he says, an accused person is not committed for trial on the ground of present guilt, but because there is reasonable ground for presuming him to be guilty. This court has indeed an unlimited right in all cases to bail the accused, and the magistrates have had the right to bail in felony, even notwithstanding such persons shall have confessed the matter laid to his or her their charge or not. Notwithstanding such justices shall not think such a charge is groundless, or shall think that the circumstances are such as to raise a presumption of guilt. There are three circumstances, generally speaking, to be considered: the nature of the charge, the evidence, and the punishment. Here the charge is for willful murder, a confession before the magistrates, and the punishment by law is capital punishment. On these grounds, there is a probability that no amount of bail will secure the prisoner's attendance to their trial. So again, it's fact sensitive, but the point is, I think these cases make good the proposition that the court had jurisdiction to grant bail and did in fact exercise that jurisdiction so to do pre and post committal.
Can I, if you're right about the common law, then Section 31 of the 1917 Ordinance is merely a reflection of the common law.
Indeed.
Yes.
Indeed, my lord, that is correct. My lord, can I turn now to what is a very important point in this appeal from our standpoint, and that is, it is conceded, and it is not in dispute, that Section 5 abrogates the fundamental rights of the respondent. That is conceded. It was conceded in the court below. That's not an issue.
You say in your written case, you list the fundamental rights that you say are conceded. I mean, was it conceded below that the Bail Act abrogated the presumption of innocence, or?
My lord, can I take you to the relevant page on that so I can have a look myself, because if you look at page 627 in the record in the electronic bundle. Yes, at the top of page 627. Right. These are the submissions of the appellant in the court below, in the Court of Appeal.
Yes. Yes. Well, I mean, there is a concession that there is a breach of. Yes. There's an inconsistency with provisions in Section 5(1), but I think in your written case you specify what those provisions are, and I just wondered whether the state had conceded each of those which you claim.
I don't think there was any discussion on which of the rights the concession would have applied.
But your written case seems to suggest the contrary. You list certain sections. Yeah,
those sections, to clarify, those sections are the sections we see are engaged, but not
the concession didn't go that far. No. Yeah, because I was puzzled why the presumption of innocence, for example, was interfered with in this context. Yeah.
Understood, my lord. So, my lord, but because there is a concession that Section 4, or at least Section 5 rights are infringed, the question then becomes, and if we're satisfied that the law was not saved because there was no general prohibition against the grant of bail pre-1976, then it means that the law was not saved. It's open to challenge. It's not immune from challenge. And therefore, if we pass the first hurdle, which is that it's inconsistent or abrogates fundamental rights, the next port of call is Section 13. Section 13, there are two clear hurdles. One is an important safeguard put in our Constitution, that is, you have to have a special majority in Parliament, a 3/5 majority. That is not an issue in this case. So you've got that special majority. The other hurdle is one which falls in the lap and domain of the judicial arm of the state. That is the test for whether it's reasonably justifiable in a society that has proper respect for human rights. And that is where we are at the moment. And my lords, an enlarged panel, because there's only one case, strangely enough, because we are a pretty litigious society, and we're troubled, my lords, on a frequent basis. But my lords, apart from that single case in the rent restriction case, no other case has come before the board that has engaged a discussion on Section 13. And when we look at that judgment, it's about 3 or 4 pages long. And the approach was a very straightforward and simple approach, that rent restriction legislation exists all over the world. It might be unfair to landlords because they're being prevented from maximizing income that they can derive from renting their property. But the reality is there's a legitimate social justification to provide housing for more people. So can I turn now to in Trinidad, this issue of what is the correct test for Section 13 and what are the parameters of that test has occupied some time. It's culminated in an enlarged panel of the Court of Appeal in Barry Francis and the Attorney General considering the point. I know at least 2 of my lawyers on this panel would be familiar with this from the Suraj case, and but even there, the discussion was on whether proportionality forms part of the test to determine inconsistency. That is to say, what is the test at the first hurdle to determine whether a law is inconsistent with fundamental rights? What is the test? How do you determine whether a law is inconsistent with fundamental rights? And the issue there in Suraj and other cases is really, well, should proportionality step into the picture at that stage? But we are not here on that. This is different from Suraj and other cases, because the inconsistency argument and what's the appropriate test doesn't arise here, because they passed the Bail Act with a special majority. So this case focuses the judicial spotlight squarely on Section 13 in a raw manner, and we've got to take the bull by the horns. So can I ask my lords to turn to page 1450, 1450, so we can have a look at the case of Barry Francis, which concerns Section 5. Seems as though that's a magical number in these challenges, which was found to be unconstitutional. Now, a couple of preliminary points. On Section 13, the court was unanimous that there was Section 13, it was not reasonably justifiable. The minority gave a lengthy and comprehensive judgment on the test to determine inconsistency and whether Lady Hale in Surat was right to import a proportionality argument at the first hurdle, and whether they were conflating these what should remain separate and distinct hurdles that should be crossed. That is to say, the first question is the law inconsistent with fundamental rights? If the answer is no, then that's the end of it. If the answer is yes, you go to the second hurdle. Did you get a special majority? If the answer to that is no, you stop there, because that is a procedural safeguard that has to be cleared before you reach the third hurdle. So if it's a law that is inconsistent with fundamental rights and you got a special majority, then you proceed to hurdle number 3, which is it reasonably justifiable? And that's the way the minority analyzes it.
Yes, and we're in the territory of focusing on the third point.
That is correct, my lord. That is correct. And for the first time in many, many years since the rent restriction case. Now, my lord, I say this because although there's been a lot of litigation and a lot of obiter comment and discussion on Section 13, I want to say this. The death penalty cases ought to be viewed with some degree of circumspection. And that is so because death penalty cases, properly speaking, never arrived at the third hurdle. The death penalty was deemed to be saved law. And if it was saved law, it was immune from challenge. So it never really arrived on the doorstep of Section 13. So that anything said in death penalty cases about Section 13, I think it's distinguishable, and it might be obiter dicta. And then in this judgment, we'll address certain questions that I take you through it that were raised by the board. So because it's a very lengthy judgment, can I start firstly with the minority dissent judgment, because it comes first in time, because it's the Honorable Chief Justice and Justice of Appeal Jamada, as he then was, who has now been elevated to the Caribbean Court of Justice. And at paragraph 1, at page 1458, we're immediately told that the joint opinion of the minority is on the single issue of whether, in determining whether when legislation is inconsistent with the Trinidad and Tobago Constitution, a proportionality test as suggested by Baroness Hale is an appropriate means for resolving that issue in the context of legislation passed by a simple majority and not pursuant to Section 13 of the Constitution. I say that because I want to put the minority judgment in context. It does not deal with a law that was passed in accordance with Section 13, i.e. special majority. But it does contain some interesting information which I think helps us to understand Section 13. Can I take you to 1470? Because it's important to understand the history of our Constitution. Sir Ellis Clark, at paragraph 38, who was one of our first Attorney General and the first head of state, at the discussion at Marlborough House on the Constitution, the draft 1962 Constitution, he said this: I believe this is perhaps the most controversial chapter in the Constitution. Perhaps that is not surprising. The subject of fundamental rights and freedoms of the individual is a comparatively new one to British jurisprudence. And I believe that we are still here expecting to follow the system of British jurisprudence. First of all, in order that everyone should understand the significance of this chapter, may I say to you what many who are lawyers are thoroughly versed in this particular subject will already know, that is, in dealing with the question of human rights, we are proceeding again on a certain accepted basis, and that is, that basis is that in the system of law with which we are familiar, the supremacy of Parliament is accepted. That is to say, power resides in the legislature to make any law it thinks fit, and the courts are not empowered to declare an act of Parliament invalid because that act is unreasonable, unjust, or manifestly erroneous, or oppressive, or anything else. That is the system that exists today. That is the system in the United Kingdom, and that is what we might term the Westminster pattern. Now, I pause there because the short point is Section 13. When you take that backdrop, Section 13 was meant to impose a restraint on Parliament. Because prior to Section 13, what Sir Ellis was saying is that Parliament had carte blanche authority. There was no restriction. Parliament can do what it liked. And he was saying, well, look, that was the position in the UK where Parliament was supreme. And in Trinidad and Tobago, it was the Constitution that will be supreme, the supreme law, and Parliament would be subject to the Constitution. So Section 13 immediately must be viewed through the interpretative lens of a restriction on Parliament's power. He then says, so we begin with this at the moment Trinidad and Tobago with full internal self-government that there is no law the legislature may not pass. If we delete Chapter 2 from the Constitution, we retain that position. So that's the backdrop. I take you next to paragraph 39. We note the recognition and acknowledgement that the provision has to be made in the Constitution to describe with precision the extent to which Parliament can be permitted to infringe the fundamental rights once they were declared as such. Underlying this recognition is a clear acceptance that the Declaration of Fundamental Rights and Freedoms in the Constitution placed them at the heart and center of the constitutional balance struck between government action, executive and legislative, and human endeavor. The judiciary, as the third arm of the state, was empowered and entrusted to maintain that balance and given the constitutional duty and power to be the final arbiter in relation to it. Now that's important because if the judiciary is meant to be the final arbiter, it is the argument about judicial deference to executive policy has to also be viewed through that interpretative lens. It is not that you can't show deference to the executive, but the point is, it is not the extent to which and how much weight that will carry will depend on the facts of the case, I suspect. Because while some say there's no pecking order in the fundamental rights, the right to liberty is of paramount importance. So I say that, yes, there must be some measure of deference to the executive, but it is not to be elevated. The height of that is not to be elevated in a way that blurs or diminishes the importance of the role given to the court in Section 13 to be the final arbiter. Now, I take you next to paragraph 41. What is immediately noteworthy in is the degree of detail in the discussions about the wording of the proviso. Indeed, what subsequently appeared in the 62 Constitution and was continued in 1976 did not contain the words "in a democratic society," but the words "in a society that has a proper respect for the rights and freedoms of the individual." Why were those latter words chosen and not the former? Also, note that the proposed draft stated the exception in the positive, but what finally appeared in the Constitution framed it in the negative. That is to say, is shown not to be reasonably justifiable. I rather suspect, my lords, that shown to be reasonably justifiable, which was what was in the draft, might have imposed, it might have been thought that imposed a burden on the state to prove that it's reasonably justifiable if the words shown to be reasonably justifiable was used. By changing it and switching it to shown not to be reasonably justifiable, the inference could be drawn that that places the burden on the applicant, and we accept that burden in this case, and we say we've met it. I take you next, my lords, to page 1479. And at 1479, sorry, my lord, can I skip that and go quickly to, if I go next to page 1505, beg your pardon, 1505. And you'll see the heading Section 13 of the Constitution at 107, paragraph 107. What has been the approach of the courts to Section 13 of the Constitution?
Is this still in the minority judgment?
It is, my lord, yes.
Thank you.
It is. But it's a five-member panel. This is the Chief Justice and Justice of Appeal Janada in their dissent.
Sure.
So what then has been the approach of the courts to Section 13? That is the crucial question in these appeals. Because after all is said and done, these appeals involve the specific issue as to whether the Dangerous Drugs Act Section 5.5 is reasonably justifiable in a society that has a proper respect for the rights and freedoms of individuals. And they go immediately to the triage of cases. De Freitas, which we know, and then we go next on page 1506. The test in De Freitas is at paragraph D. Then they go to Northern Construction, and at paragraph 111 you will see that Northern Construction was important because Justice Jamada was the judge at first instance, and the judgment was overturned in the Court of Appeal, and there's a discussion there about that. But you will see he says at letter G, paragraph 111G, in the Court of Appeal, Archie J.A., as he then was, in delivering the unanimous judgment of the Court of Appeal, applied the Nyambri test as endorsed by the Privy Council and De Freitas as the means to determine reasonable justifiability for the purposes of Section 13. And that was, is the legislative objective sufficiently important to justify the limitation? The measures designed to meet the legislative objective are rationally connected to it, and the means used to impair the right or freedom are no more than is necessary to accomplish that objective. And we say, my lords, that this Section 5 fails, on all three if we use that test. And then we go to page 1508, where they discuss the rent restriction case of Morgan and the Attorney General, paragraph 116, at page 1508. And they say, in Morgan, the Privy Council did not expressly apply the proportionality test to the inquiry whether the Rent Restriction Act was reasonably justifiable. The act had been passed with a special majority. The Privy Council found the act to be reasonably justifiable and dismissed the appeal. Lord Templeman's approach was simply to consider that rent restriction was known and practiced in many societies that had a proper regard for human rights, and that such restrictions on the enjoyment of property are reasonably justifiable. Now, I don't think that Lord Templeman can be faulted for taking such a simplistic approach in a case that deals with rent restriction. But in a case like this, because the rent restriction, it's an indirect interference with your right to use and enjoy your property, because you can rent it, but it's just the amount of income you can derive is indirectly restricted. But can you take such an approach, and can we adopt a one-size-fits-all on a Section 13 test? When it involves, take for example, a case like this, the right to liberty, the right to freedom of expression. That's why
I'd understood the appellants to be conceding that what occurs in other jurisdictions can be taken into account under Section 13.
Indeed.
And this would be authority for that proposition, but in a slightly different context.
Indeed, my lord.
Yeah. And you've provided a list of all the countries you've gone through that have bail applications for murder.
Yes.
Yes. Yeah.
My lord, interestingly enough, in that list, there are a number of countries where there were legal challenges, and they all succeeded. So that on that list, some of them would have had a Section 5 that was overturned by their own courts. My lord, if, for example, we've cited a case from Ghana, for example, and in that case, the blanket prohibition for bail was overturned on the ground that the presumption of innocence, it collided with the presumption of innocence and could not withstand constitutional scrutiny. You will find that case just for notification at page 2484 of the electronic bundle, 2484 to 2592. But I won't take you there, but it's a lengthy judgment from the Ghanaian courts, and the relevant parts would be at 2484 to 2592. But it's interesting because every time a challenge was mounted, the judgments have all gone in one direction, and insofar as we're to take cognizance of what the international norms may be. I suspect that that may apply to the judgments as well, because they all head in one direction. But can I return to page 1508 and the decision in Morgan? So in formulating a test, my lord, bearing in mind the innumerable permutations that can occur, the test has to, by necessity, the test has to be one that is flexible. It has to be one that may contain limbs, but it is not one that can be exhaustively and definitively defined. Because, you know, and I'll come to why I say that in due course, because I think so many factors can be relevant in this case that may not be relevant in another case, and vice versa. Can I take you over, leave to page 1509? At letter D, you will see they say Lord Templeman made reference to many societies which pay proper regard, and we accept that inquiry must not be limited to the context in Trinidad and Tobago, but must include other societies that are recognized as having a proper respect for the rights and freedoms of the individual. Page 1510, we have the summing up, and the summing up is this. It is clear, paragraph 125, that the process of analysis contemplated by section 13 involves 3 discrete but interrelated steps. First, the determination of inconsistency. Second, the determination of reasonable justifiability. And third, the determination of the core, inviolable, and relevant standards of a democratic society against which the provisions challenged must be ultimately measured, and the undertaking of that measurement. So that's the approach, the minority, that's the formula. Speaking for the respondent, my lords, we say that that is a useful formula, it's a valuable formula, provided it is not straitjacketed, and we understand that we must always leave the door ajar for further considerations. They go on to say, however, because section 13 requires the justifiability to be reasonable, proportionality tests are an obvious tool that may be used to assist the courts in determining section 13 challenges. And they say, indeed, in northern construction, Parliament, as an initial filter, when it intends to pass legislation which, though inconsistent with the Constitution, it seeks to render effective pursuant to section 13, having done this, Parliament ought to go further and test the proposed legislation as against the constitutional values that a society that has a proper respect for human fundamental rights and freedom recognizes. One ultimate test for section 13. We therefore say that the standard of justification for limits on section 4 and 5 rights and freedoms refers the court to, in its inquiry, back to the constitutional values entrenched in those very sections. A court must be guided by the values and principles which are embodied in due regard for the rights and freedoms of the individuals. Examples of those overarching constitutional values are to be found in the preamble to the Constitution. It is these and the other overarching constitutional values and principles, such as respect for the dignity of the human person, the rule of law and separation of powers, that are the final standard against which limitations on and restrictions of the rights and freedoms must be shown not to be reasonable and demonstrably justified. This is the effect of the analysis that Barrow J.A. has undertaken in relation to section 13, the outcome of which we agree with. So, my lords, the new dimension that the minority has added is really that the determination of the core, inviolable, and the relevant standards of a democratic society against which the provisions challenged must be ultimately measured, and the undertaking of that measurement. So, That is a third hurdle or third limit in the test that is separate and apart from the reasonable justification, reasonable justifiability.
How can it be separate and apart from it?
Well, my lord, perhaps I should seek refuge in the fact that he prefaces it by saying they're interrelated, because it would be difficult to.
Well, at the end of the day, we are interpreting the words about something not being reasonably justifiable.
Yes.
So at most, there can be a gloss on those words.
But indeed, my lord, or it may very well be that it might be a strong relevant consideration to which the court must have regard, and that is it's subsumed under whatever formula we devise to implement as part of the Section 13 analysis. But I hear you, my lord. It's difficult. I mean, to view it in a hermetic and compartmentalized manner, one isolated from the other, it does seem to be, it would be strange. I mean, I think, there are obvious points there would be overlap and points of intersection. The next thing the minority did, my lord, is to look at what they deemed, what they thought might be maybe some conflicting interpretations in judgments from the board, and they're all in death penalty cases. At paragraph 130 on page 1512, they started with Rudall, and they say in Rudall, in any event, the question arises whether interaction between Section 4 of the 1925 Act and the Interpretation Act must be approached as always speaking legislation to be construed in the world of today. Now, this is important because an issue arose during the course of yesterday as to whether we view the legislation as the appellants have submitted in 1994, as though we take a snapshot of 1994 and it's frozen in time. We say that is not sensible, it is not practical, it's not reasonable, and that is not the correct approach. And that is why. So that's the startup in Rudall, and then at paragraph, so that's the majority judgment in paragraph 130 with Lord Stein, and then they go to the minority judgment with Lord Roger in paragraph 131, and at the bottom of the page he says the judicial task is to interpret the Constitution in order to determine where the balance is drawn, not to substitute the judge's views where it should be drawn. And then there's a whole lengthy passage, and then they come to page 1514, paragraph 132, and we come to the Boyce decision. They cite Lord Hoffman's majority opinion, and at paragraph E to F, he says, the terms in which these provisions of the Constitution are expressed necessarily co-opts future generations of judges to the enterprise of giving life to the abstract statements of fundamental rights. The judges are the mediators between the high generalities of the constitutional text and the messy detail of their application to concrete problems. And the judges, in giving body and substance to fundamental rights, will naturally be guided by what are thought to be the requirements of a just society in their own time. That's present day. In so doing, they are not performing a legislative function. They are doing the work of repair by bringing an obsolete text up to date. They are not doing the work of repair, by bringing an obsolete text up to date. On the contrary, they are applying the language of these provisions of the Constitution according to their true meaning. The text is a living instrument when the terms in which it is expressed in their constitutional context invite and require periodic re-examination of its application to contemporary life. I commend that passage to this board. And then he says, at the bottom of the page, all of this is trite constitutional doctrine, but equally trite is the proposition that, and I want to stress these words, not all parts of a constitution, not all parts of a constitution, allow themselves to be judicially adapted to changes in attitude and society in the same way. Some provisions of the Constitution are not expressed in general or abstract terms, which invite judicial participation. in giving them practical content. They are concrete and specific. And he gives the example of the Barbados Constitution and the provision that Her Majesty shall be the head of state. Now, I think this is important because in the death penalty cases, one can readily appreciate why there is no invitation to the judiciary to engage on any kind of exposition as to what the law should be, because it is saved law. And that's the context in which that statement is made. But outside of that, that's why I stress the words, not all parts of a constitution. But when you come to Section 13, Section 13 extends a golden invitation to the judiciary to please get involved. You are the final arbiter. And that is why when it comes to Section 13, I commend the passage from Lord Hoffman at letters E to H about interpreting, applying it in light of constitutional values in your own time. And then at page 1516, letter C, 1516, letter C, he says, in laying down this rule, the Constitution employs no general concepts which need or invite being given a contemporary content by the courts. They are the protected laws and the extent of their immunity from challenge are stated in the most concrete terms. And that's the point, my lords, that there's no invitation to the judiciary when it comes to saved laws. And what you think about it as to whether the death penalty is good or bad or ugly, that doesn't matter. It's saved and it's immune from challenge.
I don't think any of this is in dispute. I mean, the board, an expanded board, has reviewed the matter recently in Chandler.
Indeed, my lord. But well, my lord, perhaps I can say what I intend to say later, my lord, which is this. I intend to ask that Chandler be confined to a saved law case in terms of the learning therein, and I'll come to why I say that.
But Chandler doesn't address Section 13.
It doesn't. That's the point, my lord. Correct. I'm obliged. But, my lord, it may be relevant to the secondary argument about the separation of powers, and whether or not that presents a discrete ground of challenge in any event in a non-saved law case. But, my lord, I'll come to that in due course.
Could I just make a point here, or ask you? Two aspects, really. First of all, are you submitting that there is an important difference between what we're being asked to do applying the always speaking idea, as opposed to if one weren't to apply an always speaking approach? In other words, are you saying that this case may turn on whether we're looking at matters today or back in 1994?
I don't think it makes a difference, my lord, but the only reason I make the submission is because the appellants made the submission yesterday that you're meant to look at this through the eyes of Parliament in 1994 and not by reference to contemporary values today.
But in a sense it becomes theoretical then for the purpose of this case, because you're not denying that it would be the same result whichever approach one applied.
No, that's correct, my lord, yes.
The second is, I'm going to be helped, really, because a lot of this you're giving us at a high level of generality. You're saying it's multifactorial. Whatever test we're going to apply ultimately, we need to know what are the factors that you are saying to us are important, and the weight that we're, in your submission, got to give to them. So I would at some stage find it very helpful if you came down to the specifics of what are these factors, in your view, that will push you one way or the other on the question of the Section 13 test, whatever that may be.
Can I address that immediately, my lord? And I'm grateful for your prompt. My lord, we say that it's not reasonable, the Section 5 is not reasonably justifiable because it is arbitrary. It arbitrarily and excessively invades the right to liberty. And we say it affects multiple fundamental rights. The right to liberty, the right to protection of the law, the right not to be arbitrarily detained or imprisoned under Section 5(2), and obviously the right not to be deprived of bail without just cause. And we also say, my Lord, that it engages the right to presumption of innocence. We don't need to succeed on all 5, but yes, and it may amount to cruel and inhumane treatment depending on the conditions, or just by itself. Now, the reason that, so those are the rights that we say are involved.
Just by itself, the cruel and inhumane treatment is tied in, as I understood it, with the conditions in the prisons.
It is, my Lord, yes.
But you also added in by itself. In what way would it be cruel and inhuman by itself?
No, I think I should withdraw by itself, yes. Yeah. I'm obliged, my Lord.
And could you expand on the right to innocence?
Yes.
That is, I presume you're submitting that to deprive somebody of liberty for a long period of time in a prison when the law presumes the person to be innocent is a breach of the presumption of innocence.
Yeah, well, the way I put it is this. The right to bail is a corollary of the presumption of innocence. And I would say this. Because of the length of the pretrial delay and because of the conditions which one is made to endure, we say that really is tantamount to inflict to a sentence. It is tantamount to a form of punishment that is being meted out to the defendant, who is supposed to be presumed innocent.
Well, is there jurisprudence in Trinidad and Tobago which suggests that the deprivation of liberty is of itself a breach of the presumption of innocence?
No.
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 At the moment, I'm struggling to see how the presumption of innocence comes into this at all, because the person is either given bail or not given bail without any conclusion being reached as to whether or not he is guilty. One looks at the offence, one looks at the nature of the evidence to make sure that there is at least a case to be tried, and what one is dealing with is ensuring that the accused person turns up for his or her trial. Yeah. So can you encapsulate from you, in a few words, why you say that there is a breach of the presumption of innocence?
Certainly, my Lord. I shall do so and move on. We say that the right to bail, the right to make an application for bail, which is really the proper thing, the right to make because there's no right to bail. There's a right to make an application to a judicial officer for bail. And that right, we say, is a corollary of the right to be presumed innocent. And we say, where a man who is presumed innocent, the possibility of his right to make an application for bail is eliminated by virtue of Section 5, and he must therefore go straight to prison. Given the duration of his pretrial incarceration and the conditions to which he is subjected, it is tantamount to the infliction of the punishment without any form of due process. In other words, in the same way as when he's convicted, he loses his right to be presumed innocent, and therefore his detention is as a result of due process, because he had a trial, he had the benefit of a fair trial. By analogy, when he is sent to prison without any form of judicial consideration, far less intervention or order, we say that interferes with the presumption of innocence, because if ultimately he's convicted, the time spent in prison counts towards his sentence. So in substance and in effect, the reality is that he is not being treated by the system of justice as a man who is presumed innocent. He is in fact, au contraire, being treated as a man who is guilty in the eyes of the system, because it is only a guilty person who, without any opportunity or hope of making an application to secure his liberty, his right to liberty, can be sent straight to prison without any possibility of a right of access to justice. So it is in that way we say the right to the presumption of innocence is involved. I can't press further on beyond that, my lord, but that's you.
Thank you very much.
Is there any authority in this jurisdiction as to the interrelationship between bail and the right of innocence?
No, my lord. This case is novel in that regard, and I can't say that I found anything in that regard. But sorry. In Daniels and Omer, at first instance, Justice Gobin, it's in the bundle, and we'll come to it, Justice Gobin did deal with it, but that judgment was reversed on appeal.
That was the case of Daniel, did you say?
Daniels and Omer. So we say those are the rights that are involved. We also say that the right to liberty is among the most fundamental of rights protected, and therefore it merits greater and more anxious judicial scrutiny when the law that is under challenge interferes with the right to liberty. We then say next, my lord, as to why it is not reasonably justifiable, we say next that it is a core judicial function, a la Coriati, that is non-delegable, in that it can't be transferred, it can't be taken away from the judiciary and exercised by the executive or the legislature. And we say the court jealously guards its independence and jurisdiction because it is the guardian of the Constitution and because it is the final arbiter under Section 13. So the fact that it takes away a core judicial function and thereby deprives the court of an established aspect of its jurisdiction, which is the function of granting bail, we say that takes the power to grant bail away, and it places it in the hands of the executive, because it is the police officer who, by virtue of the nature of the charge he lays, if he lays murder as a close attempted murder or wounded with grievous bodily harm and so on, whichever one they choose, he can determine whether you go to jail for 10 to 20 years or not. Then we say the right itself is a right not to be deprived of bail without just cause. And inherent in the right, the cause is to be presented by the prosecution. But it is for the judicial officer, the right itself contemplates and countenances that the judiciary would determine whether that cause is just or not. And therefore, it is not the wording of the right itself, because of that, doesn't lend itself to a law like Section 5. Then we say furthermore, the prejudice to the accused, weighing up reasonable justifiability, the prejudice to the accused must be taken into account. It is serious and extreme and cannot be remedied. There are young men who have literally lost the roaring years of their youth in prison awaiting trial. Akili Charles spent 9 years. According to the prison rules, you get 1/3 remission. That's 12 years in prison time. Because you're entitled to a remission of 1/3 for each year for good behavior, my lord. But so normally, that would mean 12 years in prison time. And there are men inside prison for over 20 years.
I think some of the people bailed, 2 of them had been in prison on
22
remand for
years.
20 years.
Yes, my lord. Yes. And we say, to say to a man who's been on remand for over 20 years, that's over 2 decades, to say to him, don't worry, boy, you're presumed innocent. We say that makes a mockery of the constitutional right.
Do we know any of the circumstances of those cases that you've mentioned?
My lord, the circumstances will obviously vary, and I have not been involved in those specific cases. I don't know. The state would know, and we did ask for disclosure, but we've not had that. But I can say, my lord, there was one who never had a trial for 18 years. What's his name, Lemich? Jason Lemich. I'm involved in that matter. For 18 years, not a single trial. Jason Lemich. How do you spell his last name? I get it from you. Because I'm involved in that matter, so I can speak to that. 18 years, no trial. The other cases, in some cases, my lord, there might have been a hung jury. The matter might have gone to the Court of Appeal, and a retrial might have been ordered. So that might account for, in some cases, but I can speak to Jason Lemich because I know about it. I'm involved in it. 18 years, no trial.
The European Court of Human Rights, in 2 cases, has considered the matters which should be taken into account in relation to bail, as Popkov against Russia and Kokshina against Russia. And one of the quotes is, the national judicial authorities must examine all the facts arguing for or against the existence of a genuine requirement of public interest justifying, with due regard to the principle of the presumption of innocence, a departure from the rule of respect for individual liberty, and must set them out in their decisions dismissing the applications for release. So I was just wondering whether or not you've would like to consider those cases, and or alternatively, whatever other authorities you can find.
Indeed, my lord.
And,
well, my lord, I'm grateful, my lord, and my juniors have taken a note, so we will, in fact, endeavour to get those judgments. My lord, so we say, my lords, these are some of the subset considerations.
I may say that at the moment I'm having difficulty working out how the presumption of innocence is breached. If it's part of your case, I would want to have assistance in relation to it.
Well, I noticed
without any authority for that proposition, I don't see how it is breached.
I appreciate that, my lord. I do note, however, that in the passage you read, I see that the presumption of innocence found its way in the passage, but we will study it. I appreciate that. May I just say, my lord, even if we park the presumption of innocence to the side, the other fundamental rights would still be engaged.
But do I understand your case on presumption of innocence to be that if you're imprisoned without trial, if you're detained without trial for up to 18 years, that de facto
No.
Amounts to...
No, that's not the submission, my lord. The submission is this. If you're detained in prison without any possibility of access to justice to secure or regain your liberty, because you're placed in prison by virtue of a police officer preferring a particular charge against you, I say in those circumstances, we say then, putting a man in prison in those circumstances, we say that is where the presumption of innocence bites. Nice. Because you see, my lord, people may be in prison because they got bail and they can't make the conditions of bail, for example. But that's different. People may be, for a number of reasons, there may be pre-trial detention. But the point is, the distinction is, that's pre-trial detention as a result of due process. Here, there is no due process. And the constitutional right given to him, which is a right to make an application for bail, that's been eliminated.
I for one, don't think that this may be a case where we need to determine whether or not the presumption of innocence has anything to do with it. But I would invite the state to indicate the extent of their concession in relation to Section 5 of the Constitution. I'd invite them to indicate which of the subsections they are accepting are infringed.
Well, my lords, I think I indicated yesterday that so far as Section 5 of the Bail Act excludes the opportunity of going to the High Court and asking it to grant bail in, as I say, an extremely unusual case, where otherwise you might have got it before the 1994 Act, but now you can't get it. Imagine, for instance, the Mercy killing or something like that. To that extent, the opportunity of gaining bail in a case of murder or alleged murder, where previously you'd have obtained bail from the High Court, but no longer you can obtain bail because of Section 5, then that, in those circumstances, there would be a breach of your right to bail, reasonable bail. Because Parliament, I would accept to this extent, has taken away your right without just cause, but has taken away your right in very unusual circumstances to ask the High Court for bail.
So it is, the concession relates solely to the reasonable bail?
Absolutely.
Yes. That was my understanding, but
yes,
I wish it confirmed.
That is our concession, and it is quite a limited concession. Yes. We say all the other rights, there's no breach per se of any of the other rights by the Bail Act. It may, of course, be, take the 25-year example, well, then there may be other rights engaged at that point, but that's not to do with the Bail Act itself. No. That's to do with later circumstances.
Thank you.
Obliged, my learned friend.
If I could then also ask whether it's Section 5 2H as well.
Forgive me, my lord. 52H is 52F is the bail. It
is a procedure provision as are necessary for the purpose of giving.
Oh, I see. Yes. 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 The procedures.
Yes.
Well, I'm not sure necessarily. There may be procedures available, even despite the Bail Act, if you have been in prison for 20 years.
The Bail Act deprives a person of a procedure to give effect to the protection of liberty.
Yeah. Well, my lord, I can see that, yes. My lord, I think, because it takes away your right to go to the High Court.
And then Section 4, you say that none of those are conceded, is that right? Or you
well, Section 5 is meant to be, I think, what you might call a general expansion of what's implicit in Section 4.
I think you mentioned A and B yesterday.
Yes. My lords, may I think about precisely which says I concede, but I have conceded 5.2F3, I think, and I take your point on 5.
Subject to Lord Hodge, I would be very grateful for a list of the actual rights which you are conceding in writing. And so
in the unusual case that you've qualified all your concession by.
I certainly don't accept what you might call the normal person in a normal case has had his rights taken away whatsoever.
Yes, well, you've made the point based on the history of the exercise of the judicial discretion that people just don't get bail anyway.
But my lords, I will obviously comply with the request.
Thank you.
I think it'd be better that way too, because then I can get what you might call confirmation from speaking on the hoof.
Yes.
Yeah. Thank you very much.
I'm obliged, Mary. Might I just remind you, for whatever persuasive value it may be to the board, that the case from Ghana, the ratio in that case it's all based on the presumption of innocence.
You mentioned that case, and I note I haven't had time obviously to read it, but I noticed the Ghanaian case was based on the presumption of innocence. But at the moment I'm struggling to see how it comes in. But I don't wish to detain you with this matter because your appeal doesn't depend.
No, it doesn't. My lord.
Getting under that head.
It doesn't. My lord, when you use the word detain in the context of this case, it got me a little scared. But if I may move on, I thought. Now, my lords, so we said, look, these are the other subset issues. The first point is our Constitution doesn't guarantee a right to a fair trial within a reasonable time. I think that's a relevant consideration because it means that the period of pretrial delay is not such that it's not like the provision we had where if you were committed stand trial and 6 months passed, you could get bail. There's no such opportunity. That option is not there. So it's relevant to the concept of reasonable justification to bear in mind that there is no right to a fair trial within a reasonable time. The second is to bear in mind the length of pretrial detention. It averages around a decade. And
Sorry, it averages around a decade.
yes, please, my lord, yes. In this case, the Akili child spent 9 years.
I understand
Yes,
that.
and my lord, that is the information, yes, my lord.
But for
murder.
For murder, I think we need to be quite precise what you're saying.
But my lord, that's all I can say is from our perspective, the information we have, and I'll come to it because there is evidence we've put before you on this from Akili Charles, who spent 9 years inside the prison.
I understand the case.
We understand Akili Charles's position, but I mean, you have a. What is the basis of the assertion that the average for someone facing a murder charge
my lord,
is remand for a decade?
My lord, I can't say that there's been any, apart from the Hood report, I can't say there's been any up-to-date study, but we did write to the state to ask for information about these matters, and we've not had a response. And obviously, we don't have the resources to undertake such a study, but all I can say is that there is no official statistic that I can cite to my lords. But what I can say is the criminal bar, which obviously has a vested interest in this case, and the discussions I've had with them, that's the information. But my lord, but in any event, I say the length of pretrial detention is irrelevant consideration. The prison conditions is a relevant consideration. And I've given you an extract. We've provided the actual judgments to my learned friends, but the extract shows you how judges unanimously speak almost so that they can take judicial notice of the notorious fact that the prison conditions are subhuman and, revolting and horrifying. The other one would be the rate of conviction. The rate of conviction is of obvious relevance in the Section 13 analysis, because if you have a high rate of conviction, it will give some degree of assurance to a court that, look, there's a high rate of conviction. There's a pretrial detention is not that great, and the conditions are not that bad. That will give you a little nudge in the direction of the state. But where, for example, the rate of conviction is abysmally low, and the evidence we have from Mr. Larry Williams, who is a senior practitioner, it's 5%. The Hood report deals with it as well. But again, we've asked for these statistics. Again, we've not been provided. So we can only go based on what the people who work in the actual system have to say. But those are relevant considerations. And then, obviously,
we can't make factual findings on these matters on appeal.
Well, I'm not asking you to make a factual finding. What I'm saying is these are in response to my Lord Burroughs' inquiry as to getting on with what are the factors that one should take into account in this case on the Section 13 analysis. I said these are the factors, and what I will say, my Lord, is this.
But you're asking us to take as a reason in our judgment that the conviction rate in Trinidad and Tobago is low. Where do we have concrete evidence on that matter?
Well, Lord, the only evidence we have is from the affidavit of Larry Williams. Yes. But can I say this in response, my Lord? Although the burden lies on the applicant, there is a serious problem with public law in Trinidad and Tobago with the duty to make full and frank disclosure on the part of the public authorities and state. And it must surely be that there comes a time when the shifting burden, a principle of shifting burden, may arise in a constitutional claim. And if it is that an aggrieved citizen in an important case like this, what I'm asking you to find is that these are relevant considerations. I'm not asking you to make a finding of fact, but if you find that as a matter of law, they are relevant considerations, and the evidence regarding those relevant considerations could only possibly have come from the state, and they were asked to produce it, or they did not produce it, so that the court can say, well, look, the legislation was justifiable, then what's the inference to be drawn? And how should the board treat with that? in the new era of litigation when we should have all cards face up on the table. My Lord, that is part of the problem. You see, my Lord, in far too many cases, much is being asked of the aggrieved citizen. Akili spent 9 years in prison, got off on a no-case submission. He can't satisfy these requirements. Now, my Lords, on the last point of the, after the rate of conviction, I go to the psychological, financial, emotional impact of pretrial imprisonment on the individual, and that was dealt with in a case of R versus Hall, and I'll just give you the reference for the passage that is set out in our submissions in the Court of Appeal. It's at page 280 to 282, 280 to 282. And of course, in appropriate cases, I mentioned earlier that there may be other considerations that may arise in a different case. For example, the level of political stability in a country, the level of independence which the judiciary enjoys, the level of independence which the police enjoy, whether it's a democratic state based on the rule of law, and its human rights track record. Those things may be relevant. I'm not saying it's relevant in this case, but I'm just giving examples of why we shouldn't have a hard and fast rule under Section 13. And the other point is that this law, Section 5, it interferes with the right of access to justice, because it renders it meaningless, because it's not legally possible for you to make an application for bail to any court. And that breaches a cardinal principle and feature of a sovereign democratic state that is based on the rule of law. And to that extent, may or may not engage sections 1 and 2 of the Constitution. We say it does.
Well, Lord Stevens has referred you to Section 5.2h in that regard.
Yes, indeed. Yes. And in Whiteman and the Attorney General, Section 5.2h and the procedural provisions that are given, the right to make an application for bail could easily fall within Section 5.2h. So we're grateful for that. Now, the deference to the executive. I don't know, my lords, that whilst it is a point to consider, I don't know if too much should be made of it. I've put in the supplemental bundle from this morning, the Belmarsh case. And in that case, even though we were dealing with a matter such as terrorism, I'm just going to mention it. I'll come back to it after lunch in greater detail. But the point is, it's a nice illustration of how it works. Because even though the court found that the executive had ample justification because terrorism posed a real threat, it nevertheless went on to invoke the principle of proportionality and invalidate the order that was made. So you can give judicial deference to, which is an appreciation of why the law was made. You can appreciate that, but that is separate. That doesn't assist you with the separate question of whether there is a legal justification for it in the context of a society with proper respect for fundamental rights. Now, my lord, the other point that should be taken into account is, of course, international jurisprudence and practice. And when my lord, I think my lord Kitchen had asked earlier about whether 1994 or present time would it make a difference. The only difference, I suppose, is that if the human rights jurisprudence would have been developed since 1994 to now, then to the extent that there has been Strasbourg jurisprudence and the European Convention of Human Rights and all of that, that may make a difference if you're looking at things today or 1994, because it will color the judicial lens based on the developments in the law. And we say, insofar as that goes, there is an overwhelming international consensus that a law like this would be unconstitutional. The next reason why we say this law cannot survive a Section 13 test is because it is disproportionate. There are clearly less intrusive measures, legislative measures that could have been employed. You could have done what the Canadians did as in the Pearson case, where they reversed, I think they reversed the burden of proof. You could have, greater use of electronic monitoring, ankle bracelets. I mean, there are many options open. I might just add, given that my Lord Hodge said he was familiar with the crime rate in Trinidad, might I just add, the fact that there's been no bail for murder hasn't helped the murder rate. In fact, the trajectory has been in the opposite direction, if anything. So the short point is, insofar as the measure is meant to full service a legitimate aim, do we also take into account that the aim you cannot accomplish and you're not able to achieve the aim by virtue of the measure in any event?
Well, it might have been worse.
Well, that might be said, my lord. But well, I suppose, yeah, that might be said, my lord, by way of response.
There might be an argument for making even more severe measures.
Yeah.
Could be, but it wouldn't. But not even if that is hoisted to the highest point can it justify taking away jurisdiction from the court. But my lords, I press on. And now, my lord, the other point we say, which is why it fails on Section 13, is the standardless sweep. It's a standardless sweep across the board. And you see, if the prosecution's case is tenuous at the preliminary inquiry, or if it's strong, it would make no difference. But we've seen, for example, in the cases at common law, where one defendant gets bail and the co-defendant doesn't get it. The wife got bail, the husband didn't. There are children. This board dealt with the case of Sipasad. There are children who are charged for murder who are in prison. And they're detained. They are detained until they're 18 and transferred to an adult prison. So whether you're sick, the elderly and infirm, you are detained if the charge is murder. Whether it makes no distinction between that and a youthful offender who can withstand the rigors of prison life. The battered wife who retaliates and murders her husband is on par with the husband who beats his wife to death. The father who kills a bandit during a home invasion after he raped his daughter, he is treated on par with the bandit who invades the home, rapes and then murders a young girl. Can they really be said to be subject to the same principle of no bail? Crimes of passion, the victims of infidelity who kills in an emotional rage is treated on par with the husband who kills his wife in cold blood. So the point is, it is arbitrary. And the standardless sweep is such that it cannot pass muster under Section 13. And of course, there is the structural breach with the separation of powers, which in the Court of Appeal, perhaps it's a judicial premonition of what was to come in Chandler, but they did not allow a Section 13 challenge as a discrete, separate ground of challenge. What the Court of Appeal said is the separation of powers and rule of law argument is a factor that comes into play in the Section 13 analysis. In other words, if there is a breach of the separation of powers, that is a relevant factor to which a court must have regard under Section 13. In other words, if it breaches separation of powers and the rule of law, it's hardly likely to be reasonably justifiable. Now, can I go next to the case of Hernam and the state of Mauritius at 2432. And in this case, which dealt with the right to bail, The board allowed, at 2432, the head note held, allowing the appeal that the purpose of the act was to recognize the right of to personal liberty as an important constitutional right and re-establish that the rule was that a suspect should remain at large and his detention on the grounds of suspicion was the exception. That the seriousness of the offence and severity of the penalty likely to be imposed on conviction might provide grounds for refusing bail, but they did not do so of themselves without more. The Supreme Court had erred in treating the seriousness of the offence as an all but conclusive reason for refusing bail, and that accordingly the order of the Supreme Court would be set aside and bail would be continued on the same terms as those granted by the board. Can I take you to page 2435, paragraph 4? Just as a footnote, to note that the board said 2 points may be made on sections 3 and 5. They reflect in very explicit terms the tension which may exist between rights of the individual and wider interests of the community. The Constitution seeks to strike a judicious balance. And then they go on to say that these rights bear very close resemblance to Articles 5 and 6 of the European Convention for the Protection of Human Rights and Fundamental Freedoms. This is not surprising, since, as has been pointed out, Chapter 2 of the Constitution reflects the values of and is in part derived from the European Convention. It is noteworthy that the European Convention was extended to Mauritius while it was still a crown colony before it became independent. Thus, the rights guaranteed to the people of Mauritius under the European Convention were rights which on independence have existed and shall continue to exist within the terms of Section 3. This is a matter of some significance. While Mauritius is no longer a party to the Convention or bound by its terms, the Strasbourg jurisprudence gives persuasive guidance on the content of the rights which people have enjoyed and shall continue to enjoy. I think the same point is made in our written arguments about the fact that Trinidad and Tobago was in a similar position pre-independence with respect to signing on to the convention. At paragraph 7 on page 2436, 2436, paragraph 7, the terms of Section 8 prompt 3 observations. First, while specifying the circumstances in which a detainee shall not be entitled to be released on bail, the Act nowhere, save in Section 4, provides an entitlement to such release. So you're depriving a man of bail, but you're not making any corresponding provision for him to actually secure his release, which is the same position here. That entitlement must be found in the general right to liberty, protected by Section 5 of the Constitution, and by implication from the negative terms of Section 8, suggesting that bail must be granted in cases not falling within the prohibited categories. The language appears to assume that the seriousness of the offence with which a detainee is charged, whether provisionally or otherwise, and the heavy penalty may of themselves render continued detention necessary so as to disentitle the detainee from any right to be released from bail. And then paragraph 84, following the 1989 Act, a series of decisions treated the seriousness of the offence and the heavy penalty provided by law as enough of themselves to justify the refusal of bail in certain classes of cases. Now, this part is relevant to our case, and it is the submissions made by the appellant. And they say, in a number of cases, at the bottom of 2436, it was recognized that the court had a discretion, but the grant of bail in such cases was said to be contrary to, unquote, an invariable practice, unquote, a well-established practice, or an established practice, or, as in the Buckley case, it was never allowed. That deals with the submission made by my learned friend about the past practice or judicial custom that they thought existed at common law, that you don't get bail for murder, to the extent that that submission was made. It's clear, judicial discretion pursuant to a jurisdiction conferred on a court is different from the question of whether the court has jurisdiction. Whether the court has jurisdiction is a prelude to whether or not it can exercise a judicial discretion. pursuant to that jurisdiction that is conferred. And the point here is that even if, taken on its highest, the appellant's submission is that the jurisdiction may have existed, but there was a settled practice of not granting bail. And we may recall the submissions my learned friend made about, well, why did anyone challenge this? The 18 amendments, the Law Reform Commission, the Constitution Commission chaired by Sir Isaac Hayatali, no one bothered, and because the settled practice in their view somehow crystallized into a binding rule of common law that formed part of the corpus of saved laws. And we say this passage here and this judgment shows that even if that was so, it doesn't take away, it does not negative the existence of the jurisdiction of the court, and the settled practice would not...
Could you refer me again to the page number, please?
That's on page 2437 at the top. 2437.
Thank you.
The jurisdiction was there, but was never exercised because of a settled practice to grant bail. And the board did not find that to be of any...
There's an implicit criticism here of the fact there was an established or settled practice at all.
Sorry, my lord?
Is there not an implicit criticism in paragraph 8 of the fact that there was, or may have been, a well-established practice or established practice in the first place?
Yes, my lord, and that's, well, that accords with our own case because we say there was no such established practice. But to the extent that even if there was one, we're saying it still wouldn't negative the jurisdiction of the court.
No, I don't think you need to go back onto the existing law point. I mean,
sure, my lord.
We've really covered that. What we're looking for is guidance on how to apply Section 13.
Indeed, my lord.
Thank you.
Might I just, in closing, my lord, on this point, and take you to page 2443, just to note that the issue of no bail, a non-bailable provision would have come up in the case of Caballero and the United Kingdom and SBC and the United Kingdom. Those judgments are there. You'll find the Caballero judgment at page 2180 in the electronic bundle, and you will find the SBC case at 3084. And can I then turn...
What are you wanting us to take from...
Well, what I want you to take, my lord, is that this is it reflects part of an international judicial consensus that the right to bail is a sacred right, and legislation that seeks to deprive someone of the right to bail is unconstitutional and a breach of their fundamental human rights.
I don't think I mean, there may be a lot of provisions about bail in different jurisdictions, but I don't think they rely upon a constitution in many of the jurisdictions to which you've referred.
That's possible, my lord. Yes, I accept that.
So there may be legislative consensus, and the judges may be implementing that consensus. But I was just...
Even in the question of whether there's a judicial consensus.
Yes.
Yes. But, my lord, I've put before you several cases where no bail provisions have been considered and issues arising therefrom. And, you know, in the Canadian case of Pearson, in the Nation case from the Jamaican Court of Appeal, in the Caballero case from the European Court of Human Rights, in all of these, and in the Ghanaian case, in all of these cases and in the judgments, they cite other judgments which dealt with a similar point. In none of them has it ever been held that there is room to accommodate, you know, the right, a no bail in the context of fundamental rights. Can I then go next to page 3281? Now, my lord, I'm bearing in mind what the court has said about the guidance, what would be of assistance in terms of the Section 13 test. And I ask equally that you bear in mind that apart from the Morgan case, this is the first case from Trinidad to come on that. So I'm going to take you to some judgments from the Caribbean, and this is one such case from Grenada, the Worm versus the Commissioner of Police of Grenada, and this had to do with the offense of criminal libel, and it was held that the section at page 3281 at the bottom, the Constitution protected freedom to publish material discussing political matters and the conduct of public figures, subject to the limitations set out in section 10.2, that the protection of good reputation was conducive to public good and was in the public interest, the falsity accusing someone falsely of a crime or misconduct in public office was sufficiently important to justify limiting freedom of expression, the offense was rationally connected to the objective and was limited to situations where the publication was not for the public benefit, and therefore, and they go on to say, since criminal libel was to be found in the law of many democratic societies, including England, Canada, and Australia, it could be regarded as a justifiable part of the law of a democratic society in Grenada. So the markers here would be, they considered what was the status quo in other democratic societies. They considered that there was a rational connection between the objective, and they considered whether the objective was sufficiently important to justify the restriction on the fundamental right. In other words, this seems to be an application of the test in de Freitas. And then I take you next to page 3257. And this is a case from Antigua and Barbuda concerning the Money Laundering Prevention Act. And I take my lords to show you that the test that was applied in this case, this is a fairly recent judgment, it's 2020. And if I take you to page 3271, and I notice my Lord Hodge was in this matter. At page 46, we are told what the issues are. One, whether the legal nature of the civil forfeiture order regime in the Act is criminal or civil, and whether the regime is inconsistent with sections 379 or 15 of the Constitution. And if I take you next to page 3275, at 3275, paragraph 72, in examining the application of section 15 of the Constitution, the parties of the courts below have proceeded by reference to the European and United Kingdom authorities on Article 6 and 7. Article 6 states that in the determination of civil rights and obligations or any criminal charge against him, entitled to a fair and public hearing within a reasonable time by an independent tribunal, and that everyone charged with a criminal offense should be presumed innocent until proven guilty according to law. The board considers, paragraph 73, the board considers that it is appropriate to proceed the same way, albeit with a degree of caution. The ECHR is not in identical terms to Chapter 2 of the Constitution, but the scheme of Chapter 2 and many of the fundamental rights and freedoms which are protected by the provisions in that chapter are broadly similar in terms of structure and drafting to those protected under the ECHR. Within liberal democracies such as the UK and Antigua, it would be surprising if instruments designed to protect fundamental rights were intended to operate in very different ways or with widely divergent effect. Further, British lawyers had a major role in drafting the ECHR as well as the Constitution, so similarities between them are not accidental. Accordingly, the board considers that the European and United Kingdom decisions to which it was referred by the parties are relevant as persuasive authorities on the interpretation and effect of the Constitution. This is in line with the board's approach to the interpretation of similar constitutional instruments, see Papanet. The degree of persuasive force of the authorities of the ECHR will depend on the text of the provision under review and its place in the general scheme of the ACHR and the local constitution, respectively. There is a close similarity between the criminal aspect of Article 6 and 15 of the Constitution, both in terms of text and protections that are designed to afford the individual under the scheme of both instruments. Now, my lords, I think that might be the two main tests, really, are the one outlined by the Privy Council in the De Freitas case, and the modern embellishments to that in Bank Millat. Those are the as close as we can come. And Lord, I don't know that it I can ask the board to say that those principles and that formula is something that would not apply to Trinidad and Tobago. As noted by the board in the Worm judgment, the corpus of fundamental rights, whilst they may have slight variations, the body of it, which is umbilical cord to Magna Carta, it would remain in substance. They're similar. You might have some permutations here and there, but in reality, broadly speaking, they are the same rights. And one cannot expect that there'll be widely divergent practices. But in the UK, the proportionality principle would be relevant to an evaluation under Section 13. And
if it was relevant, is the legitimate aim the prevention of crime and disorder?
Sorry, beg your pardon.
Is the legitimate aim of Section 5 of the Bail Act the prevention of crime and disorder?
Well, my lord, I think that's the appellant's. I would say so. I think that's what the appellants are saying.
Do you agree with that?
No, I don't.
What is the aim of that provision?
Well, my lord, no, that might be the aim, but whether it's a legitimate aim is where I have a quarrel.
But I mean, it must be legitimate to try to prevent crime and disorder, surely. I mean, you can't argue the contrary.
Well, my lord, no, I can't. No, of course not. My lord, what I mean is this: the bail is something that was designed to secure one's attendance to court.
Yes.
To convert that into a crime-fighting measure. And as something to...
That's a separate point.
Yes.
What Lord Stevens was asking you about was purely the aim. I mean, the measure may be completely inappropriate.
Yes, sure. I accept that now, yes.
And it's of particular importance in Trinidad and Tobago, given the crime rate.
Yes, my lord, certainly.
And one has to give considerable deference to the Parliament that thought that aim was appropriate.
Oh, certainly, my lord, yes. Certainly. But the issue here, my lord, is, look, the crime problem is not unique to Trinidad. Jamaica, for example, the board would be well familiar, also has a terrifying crime problem. But in the Caribbean, in the Commonwealth Caribbean, Trinidad and Tobago, I think it's only St. Vincent, apart from Trinidad and Tobago, that has this kind of provision. None of the other Caribbean islands do.
Is the measure rationally connected to the aim?
But my lord, no. We say that it's not.
Why not?
Because, my lord, when you look at...
If those people suspected of serious crimes are detained in prison, that will prevent crime and disorder.
Well, my lord, let's look at it this way. What would prevent crime and disorder is not detaining people in prison without due process. What would prevent the crime and order is having a more effective police service, having a functioning DNA lab, having more crime scene investigators. We are not a poor country. It's an oil gas-based economy with a heavy, we are among the top 10 in the world as manufacturers and exporters of ammonia, heavily involved in natural gas and petrochemicals. So it's not a poor country. And the point is, what you have to, before you go to the most draconian measure, the answer is, and has got to be, to have the resources and look at what other options may be available, as they've done in other Caribbean islands. But this is a draconian measure. My Lord, can I, on that score, to make good that proposition, my Lord, can I just take you to page 3033 of the electronic bundle? Because this is a case that was, some time was spent by my learned friends on it, Justice Telford George's. It's a High Court judgment, but this is what he had to say at page 3033. He said, it is, of course, not, at the last paragraph of the page, he says, it is, of course, not surprising that the Commissioner of Police should take this view. The exercise of constitutional rights by citizens usually creates problems for the police. Any reduction in these rights, conversely, tend to make their task simpler. If the approach adopted by the Commissioner is taken to its extreme, it could be argued that the control of crime would be made simpler and the burden on the police much reduced if the police were allowed to detain suspects indefinitely without trial. The vast majority of policemen would, I'm sure, wish to have no such powers. The criterion of effective control with minimum effort cannot be so baldly stated as it has been in the affidavit. The solution to an undermanned police force is an increase in its strength to enable it satisfactorily to perform the duties which it may be called upon to perform. And I think that's the approach one has to take. In Synonym, for example, you may recall the Chief Justice speaking about the delay in hearing criminal appeals. And he was saying, well, look, we don't have the resource, we don't have the appropriate level of staff, we don't have the right number of judges, it's a small complement, but he was explaining why the pre-trial delay, the pre-appeal time was so long. But where that happens, can we say by analogy that if criminal appeals are taking long because they're in a small complement of judges and you don't have CAT reporters and so on, is the answer for the executive to abolish the right of appeal? And the answer is obviously no. And the same point holds here. If it is that crime is a social problem, is the answer to lock them up and have a prolonged period of pretrial detention so we can all feel safer. It sounds great, but what if you were one of those locked up, like Akili Charles was for almost a decade of his roaring youth? So, my lords, we go back to the test. In De Freitas, is the legislative objective sufficiently important to justify the limitation of a fundamental right, rationally connected to the objective, and whether the means used to impair the right is no more than is necessary to accomplish the objective? Bankman gives two riders. Could a less intrusive measure have been used without unacceptably compromising the objective? And having regard, the second one, having regard to the severity of the consequences, whether a fair balance was struck between the rights of the individual and the interests of the community.
Well, I mean, a difficulty with the De Freitas and the Bank-Mellet approach, the difficulty of applying that directly to Section 13 is that Section 13 starts from the premise that the democratic legislature has knowingly departed from the fundamental rights in question. And the tests which you're proposing seem to fit very nicely into qualified rights under Section 4 and 5, but they don't seem to fit so nicely in relation to Section 13, which where a democratic legislature has, with its eyes open and in accordance with the Constitution, decided to take a step which would infringe the rights of Section 4 and 5.
Yeah. Well, my lord, that's why I started off by taking you to Barry Francis to see what informed the birth of Section 13. And what informed the birth of Section 13 is quite the opposite. It was a desire to restrain the power of Parliament. And if sections...
I mean, it was restraining. It was the end of Section 13. The proviso is a restraint.
Yes.
But Section 13, insofar as it allows Parliament to take steps which otherwise would be a breach of the Constitution, is a very unusual provision in the Constitution of Trinidad and Tobago compared to other Caribbean jurisdictions, in that it is expressly allowing the legislature to depart from constitutional rights.
My Lord, and I think I accept that, my Lord, and that's why I've raised this frontally with the board, because, my Lord, one has to bear in mind we've had elections, where it resulted in a tie, the case of Sharma and the Attorney General. We've had elections where, there was no opposition because we had a no-vote campaign and there was no opposition. So therefore, that 3/5 majority, one has to bear in mind the untrammeled and unrestricted power that the legislature could have, that a government of the day can have. And that's precisely why you had this fallback important safeguard of the judiciary being the final arbiter.
Oh, yes. Yeah. I don't think that's
sure, my Lord.
a matter of dispute.
But, Lord,
but the oddity in this case is that, which may be a point in your favour, is that the state is saying that it was the almost invariable, if not invariable, practice of the judiciary to refuse bail.
Yes.
But the state also seeks to argue that there may be extreme cases when the judiciary could
yes, of course.
Allow bail.
Yes.
And in that context, the board might ask itself the question, well, how is it reasonably justifiable where there is no evidence whatsoever that the behavior of the judiciary in relation to people accused of murders is contributing to crime and disorder, that one should abolish even a limited discretion in exceptional cases to allow bail.
Yeah, I mean the rational connection.
There's a rational connection there, but how is it reasonably justifiable if there? Yes, I think you're right. I mean, where's the rational connection between this limitation and the aim?
Yes.
Because it might on one view be seen as a populist gesture, which has nothing to do with the aim of preventing crime and disorder.
Indeed, my Lord. My Lord, on the issue of the test, let us not forget that the learned Chief Justice dealt with Section 13 and did apply the test in his judgment, and it's at page 756. So you can get some assistance from that. It's at page 756, and it's paragraph 62. And this is what he said. He said, some time was spent during oral arguments on the question whether independently of Section 13, a statute could be declared unconstitutional because it offended separation of powers. And he says, Section 13, scrutiny, is a broad and compendious examination that takes into account both the specific provisions of the Constitution and the core principles that underpin what is sometimes referred to as its deep structure. To be clear, a society that has proper respect for the rights and freedoms of the individual is of necessity, at least in our constitutional construct, a society that respects and observes the rule of law. Separation of powers is simply one structural mechanism, like the independence of the judiciary, for ensuring the preservation of the rule of law and, by extension, the protection of individual rights and freedoms. Notwithstanding the apparent differences in language in some of the leading cases and an examination of some of the seminal decisions are undertaken. But the idea was to have a broad and compendious examination, and that's the terminology that the Honourable Chief Justice used. And my Lord, I hate to say, but I mean, we can't have an exhaustive definition, but there's not much I can add except to say that in conducting the exercise as the final arbiter, I don't see that the limbs of the tests in De Freitas and Mellot can be said to be irrelevant or jettisoned.
I'm not suggesting they're irrelevant, but do you not have to build into them the fact that consistently with the Constitution, this measure has been passed by a democratic legislature using a supermajority?
Well, my lord, that brings to the question the submission about an enhanced level of constitutionality. You know, if there are two hurdles, my lord, and hurdle one has been crossed, and that is to say they've passed it with a special majority, query how much of a carryover is there from that into hurdle two?
There must be a carryover.
No, I'm not saying that there isn't.
Because the whole point is the Constitution has authorized the democratic legislature to depart from what were otherwise the constitutional norms.
I agree, but let me put it this way. Well, I guess what I'm trying to say, and forgive me for not articulating it properly before, but suppose, for example, it would depend on the facts and the measure and so on, because if the legislature passed a law tomorrow to say no left-handers shall be employed by the state, now, the measure of respect and deference to the legislature and the executive policy will obviously be far less because of the nature of the legislative provision in issue. And therefore, the deference, it's not fixed and it's not immutable. It is dependent on many different factors, I would say. And that's why, my lord, I'm not prepared, I am prepared to say, look, it's obviously a relevant consideration, but the weight to be attached by a court to that relevant consideration in the Section 13 exercise would not be something you can fix by reference to a single case. It would have to be stated in neutral terms that it's a relevant consideration. But I do not think that it leads to an enhanced presumption of constitutionality that somehow increases the burden on the applicant or anything of the sort. So that's why, my lord, I hope I've made clear my position that it's a relevant consideration, but the weight to be attached will vary from case to case depending on a number of factors. Can I next, if I can move on to a different point, and it's to take you to the judgment of the court in Chandler.
Just before doing that, I was taken with the point that Lord Hodge made,
yes,
and that is what is the rational connection between the aim and this particular measure. In circumstances where you have this paradox, namely that the Attorney General states that no one was being let out on bail for murder, and so what was the connection? Do you have any views about that?
Well, it could not have been a crime-fighting measure if it is that no one was being let out. I mean, there's no rational connection.
Yeah, well, that I think is the essence of your point.
Yes, it is.
Initially, you didn't want to agree with Lord Stevens about the legitimate aim, but the reason you weren't agreeing, as I understand it, was because the particular measure had no rational connection with the aim.
Correct, yes.
Yes.
Correct.
Yes, so that is your position, is it?
That is the position indeed, my lord, yes. So can I now move on to Chandler, my lord? And
just before you do that,
sure.
Am I right in understanding that your submission boils down to if one's got a sufficiently serious infringement of the human right, then the fact that one has got to apply a somewhat watered-down version of proportionality because of the special constitutional position that we're talking about in Trinidad and Tobago is taken into account, but it doesn't displace the fact that if it's a sufficiently serious breach, then that's it. In other words, the way, how serious the infringement is crucial in determining how deferential one might be.
Yes, certainly.
Under the special provisions that we're here talking about.
Yes, I mean, the way I put it, Lord, is that whilst deference is a relevant consideration, the weight to be attached to it will vary depending on the legislative measure and among other things. So, for example, if you had no opposition, because there was the Parliament comprised only one party in the House, that too would be a relevant consideration in terms of the measure of judicial deference to be accorded, because one would know that the opposition would be a check and balance in the Parliament that makes the law itself.
I think that's a different point, because that's querying whether one should have the deference that one should show might be affected by the state of the parliamentary position. Let's just assume that that's not in play here. We're talking about how we work out this special element of deference that one must show. And as I understood it, my interpretation of what you were submitting was that the more serious, if you've got a particularly serious infringement of human rights, then that would outweigh the deference that one is showing. Whereas, if it was a marginal infringement of human rights, then you would defer.
Correct.
Is that a fair interpretation of what you're saying?
I think so. Yes, my lord. I guess that's a fair interpretation. I mean, in Surat, Lady Hale said de minimis interference with fundamental rights are constitutionally permissible, but there must be. I mean, she didn't draw the line in the sand when we cross from de minimis into anything that is disproportionate. But the proportionality argument is what the board settled on in Surat. But what you've said, my lord, is yes, there is an inverse relationship, as it were, between the two.
And then we're required, if that's right, to ask ourselves, how serious an infringement are we here talking about? And as I understand it, your submission focuses on factors such as it's a fundamental right, that is the right to liberty that's affected, it's interfering with the core judicial function, there's serious prejudice to the accused, it's unnecessarily intrusive because there are less intrusive measures that could have been applied. There's elements of arbitrariness because it doesn't matter what type of murder we're talking about, the same approach is applied. And there's this issue about the paradoxical reference in terms of arbitrariness. That's what we're focusing on as far as you're submitting.
Correct. Correct. I mean, I'd refer you to a page in the submissions in the court with the case of R versus Hall. But we've got to understand the depth of this. When you're charged with an offence such as murder, and the death sentence is hovering over your head, and you're in prison, your life is completely destroyed. You don't have any source of income. Your children have no source of income if you're the sole breadwinner in the family. You have no funds to hire a lawyer. You have limited opportunities to give proper instructions if you did have one. I mean, your whole life, it's completely undergone, an adverse change. The impact is very severe.
But that's an argument against having bail at all in a severe case.
Well, yes, and perhaps, my lord. But the point I'm making, my lord, is here. There is no due process. That's the distinction. By virtue of my lord, if a police officer wishes, he can pick and choose from attempted murder, wounding with grievous murder. He can choose the murder charge, And if they prefer murder charge, that's it. There's no due process. By virtue of the nature of the charge preferred, you lose your liberty. No due process, and that's the distinction. So if I go next to the Chandler judgment, my Lord, this has to do with this, whether or not what we say is, because it's connected to my Lord Stevens' point about section 5 to H, the procedure, which is an application for bail, has to be made to a court of law. That's the mechanism that is provided by the sovereign democratic state of Trinidad and Tobago. If you have passed a law that eliminates that opportunity and deprives me of the right of access to justice, because I no longer enjoy a right of access to the court, then that very mechanism itself is impaired. And that is, we say, contrary to the rule of law and a breach of the separation of powers. And we say that the board did not overturn Coriati. Coriati remains good law. And insofar as a separation of powers as a separate ground of challenge might not have found favor with the board in Chandler, because Chandler dealt with a saved law. We say in a case where you are not dealing with a saved law, we ought to preserve that as a separate ground of challenge in the alternative to considering it under Section 13. And I say so because this has been part of our constitutional jurisprudence in Trinidad for quite some time.
I wonder about that, because in Chandler, there was the argument, was it or was it not a saved law? And that argument related only to the question whether any breach of sections 4 and 5 could render the matter unconstitutional. The attraction to the appellant in Chandler of the separation of powers was that he could bypass the fact that there was a protection only of section 4 and 5, and that saved law wouldn't be an answer if there was a separation of powers argument.
Yes, it's true. It was rejected because...
But if that's right, then the fact that Chandler was principally about saved law is irrelevant.
Well, the way I look at it is this. If it's a saved law, then it's immune from challenge by virtue of the saved law provision.
Immune from challenge under sections 4 and 5?
Indeed, yes, correct. And then the question Chandler decided, therefore, is a law that is immune from challenge on the ground that it breaches section 4 and 5. There is no alternative option based on the separation of powers argument that it interferes with something that is outwith sections 4 and 5, namely it breaches sections 1 and 2. And that's the way I understand it. So the question now arises, in a case where it's not a saved law, if a law breaches sections 4 and 5, in addition to section 13 as a basis for invalidating the law, could sections 1 and 2 provide an alternative basis on the ground that the law in question breaches the rule of law and the separation of powers, both of which are cardinal principles and features of a democratic society?
What does this add to Section 13, though?
Sorry?
What does this add to Section 13?
Well, in a case like this, given that the Chief Justice said this is the point that could be considered under Section 13, all I'm seeking to do is to establish that it could be a ground of challenge independent of Section 13. It doesn't add to Section 13. It's really whether it provides an independent basis. outside Section 13. But I take the point, of course, that hardly likely that you would find a law that's reasonably justifiable, but that breaches Sections 1 and 2.
I struggle to see why the board needs to go into this in this appeal at all, because you have a concession that Mr. Knox has articulated this morning, subject to its clear limitations of a breach of Section 5 in relation to a certain circumstance. In Chandler, the board was looking at the matter in relation to saved law and a separate challenge that there was a separation of powers argument, and it rejected the separation of powers argument. Here, you don't need the separation.
I don't know. I appreciate that.
If you can establish under Section 13 that the measure is not reasonably justifiable in a society which has proper regard to fundamental rights. This case really focuses almost exclusively for its determination on Section 13.
Lord, I appreciate that, and I shan't press it further. The fact of the matter is, if I get home on a breach of Section 4 and 5, it's not necessary to. I don't get the brownie points for an additional breach of Sections 1 and 2.
Well, it doesn't add to your case.
No, it doesn't. I appreciate that, Lord, so I shan't press it. I'm grateful. Lord, can I next go then to take you to the supplemental bundle from yesterday, to just highlight a couple of points. My lords have clearly seen the table we provided, which should be at page 62, with the countries, different countries with and whether the courts have jurisdiction to grant bail. I shan't take you through it, but all I can say is, for the record, in the Commonwealth Caribbean, it's, apart from Trinidad, the only other island is St. Vincent. And then I take you to page 80, and my Lord Hodges already alluded to this, that in the case of the two prisoners who were able to get bail, the length of time, and at paragraph 3, at page 80, which there should be paragraph 3 of an affidavit.
79.
It's 79 in your bundle?
79.
79.
Yes, beg your pardon. And this is an affidavit which is an affidavit of the respondent, and he says, during my time on remand, at paragraph 3, I met many prisoners who were on remand awaiting trial for prolonged periods in excess of between 10 to 15 years. Many of these persons are still on remand awaiting trial. During my time in prison, the vast majority of prisoners whose matters came up for trial were freed after they won their murder case. This is why I'm asking the appellant to produce the statistics on the period of detention and the rate of conviction for murder, as I believe it is relevant and would assist the board in making a fair and just determination of the state's application. Then, I don't know, my number is off a bit, but next, at page 78, there should be an affidavit of Akili Charles, and paragraph 5 of that affidavit is by letter dated March 25th.
There's...
Page 77.
Page 77, I'm obliged.
Page 77, paragraph 5, yes.
And paragraph 5, we wrote, I have the letters, it's in the bundle from this morning, sorry to be so disjointed with this, but you will see we wrote the other side to ask for the information. The response we got at paragraph 5 is by letter dated March 29, 2022. The Attorney General responded to indicate, we do not intend to get into correspondence with you on the merits. It will be a matter for the justices. As to how our application will be structured and the documentation annexed, this will be a matter for us and counsel. You will, of course, have the opportunity to respond. And we have not to date received any information. The Law Association, independently of us, had also written, and they also did not receive anything. And at page 86, which might probably be your 85 or 87, it's an affidavit of Larry Williams. And
It's 85, it starts at 85.
okay, I'm grateful now. So I'm looking at paragraph 3. At paragraph 3, he tells us he's a member of the criminal bar for 23 years in Trinidad. He's a very well-known guy. Paragraph 6, he says that it's noteworthy that in Trinidad, because we have Pratt and Morgan, the death sentence is no more for murder in real terms. It remains legally, theoretically possible, but the reality is since Pratt and Morgan, after 5 years, the sentence is commuted to life imprisonment.
Yes,
And
the board observed that in the Chandler case. We made that observation. There have been no death penalty carried out since 1999.
no execution since 1999.
Yes.
And the short point there is, insofar as people rely on the severity of the penalty or the likely sentence, well, in real terms, the sentence is life imprisonment.
But not wholly. I mean, the point was made in Chandler, as I recall, that the Attorney General was arguing that that one should arrange that the death penalty could be imposed to see if it would be a deterrent. That was pointed out to us that it wasn't wholly academic.
Yes.
The question of the mandatory death penalty.
It's not legally impossible. I mean, you can have, if you have
an efficient appeal system,
of course, or a prisoner who feels he's guilty and refuses to appeal.
yes, precisely. So it isn't wholly academic.
Yeah.
Would that be a convenient place to adjourn for?
Certainly, Madam.
We'll resume again at 2:00. Thank you.